The guidance counselors gathered a number of us together who represented the top 15% of the graduating class and told us about the scholarship program. It was brand new that year and encouraged us to apply, gave us the application forms. So I filled it out and sent it off. After a little while, a letter came from the governor saying, congratulations, you've been accepted into the Promise Scholarship Program. It's good for 2 years at any accredited school in Washington State. When I was in junior high school, I really adopted my faith for myself. That's something I'd inherited from my parents, but I really made it my own, and I decided that I wanted to live that out in practice through my career, and then decided at that time that the best way to do that would be through a career in ministry. I was looking for a Christian college that had a strong ministry training program. I was hoping to stay fairly close to home. So Northwest was a great fit, great atmosphere. You get to know everyone pretty well. Declare a major, you don't have to do that. I felt that I knew what I wanted to do and didn't see any reason not to declare one. All it meant for us was filling out a form during registration time where you just filled in the blank saying what major you wanted to study. I filled in pastoral ministries and business management and administration. I wanted to do a double major at the time. The business end of it I thought would be a helpful thing in leading a church. In about October, I was called to the office of the Director of Financial Aid there at Northwest, and she told me that the state had recently clarified their position on the Promise Scholarship with her. It was a new scholarship, so there was a little ambiguity in the beginning, but they had informed her that she would not be able to release any of the funds to anyone majoring in theology. My pastoral ministries degree fell within that category, so she informed me that I had a couple of options. I could change my major and I would receive the funding. I could just stick with only the business management major that I had declared. I could just go undeclared. I think I was the fourth one that she had met with, and at least two of the others had chosen to change their major. So I sort of figured out real quickly where this was going, and it was a mix of emotions. I was a little bit surprised, a little bit angry. To change my major when I had come to college for that very purpose would be to lie. I didn't want to put myself in that position, especially playing a career in the ministry. It didn't seem like a very good way to get started with that sort of thing. I kept my major and told them no thank you. I heard Jay Sekulow on the radio. He has a daily radio program where he talks about the cases that they're filing and makes people aware of religious liberties issues and that sort of thing. I knew they had done work on cases like this before, and so I gave them a call. I was thinking, though, that they might be able to help me write a letter or something and take care of it really quickly. Ended up getting a call from an attorney. They were interested in knowing more of the facts, and so I wrote out sort of a narrative of what had happened, sent that to them, and they came back and said that they thought there was a real case here.
What made Josh right, it was a real case. He was a real person that really needed that $1,532, that wanted a major in theology, and they had a broad policy that allowed everything but theology.
Just freedom and for what I thought were my rights, under the Constitution as a Christian, and to do so for other religious people who might be in a similar position later on, not just Christians, but people of all faiths, to take a stand for what I thought was a universally true principle, essentially, that people have an inalienable right to free exercise of religion and that government should not discriminate on the basis of religion. So for all those reasons, I chose to file the lawsuit.
The lawsuit received a good deal of publicity.
That day, there was some uproar on campus. People, saw me in the papers. Some people thought I was suing the school, and it was, it required a little clarification. But then, the next day, pretty much things had died down. And then that was the way it was throughout the whole process. It would be quiet for a long time, and then there would be a decision or something, and hit the papers, and there'd be a lot of attention for a couple of days, and then it would be back to normal.
Josh recalls being deposed in the case.
The attorney for the other side was just a really nice guy. It was a very pleasant experience.
In his deposition, he explained why he thought he had a good case.
I think I was really discriminated against in this case because I was eligible to receive a public benefit that was made available to everyone who qualified on the basis of some neutral criteria, academic achievement and income. Then the state came in after that and said, but if you want to study religion from a devotional perspective, we're not going to give you money for that. I don't think separation of church and state means you have to exclude religious people from otherwise available public benefits.
Josh saw his case as similar to Zellman versus Simmons-Harris, in which the Supreme Court held that a state may provide vouchers to students even if most of the vouchers were used to attend Catholic schools.
I like Zellman. I think it's a great decision. I think it's a great principle. I think it's very much like my case, where here you have a program that's generally available, a voucher that's available to parents to send their kids to private schools, and where you have a benefit going to a private individual who makes a free, private choice to spend that however they would like.
Josh lost before the district court, but prevailed on appeal to the Ninth Circuit, which agreed with him that his First Amendment rights had been violated. Washington filed a cert petition, and the Supreme Court agreed to hear the case. Josh recalls attending the oral argument.
The court is awe-inspiring to be there and see the architecture and the justices up there. And it was sort of surreal to be sitting there and have them talking about me and my case.
The Supreme Court ruled against Josh's position. In a 7-2 ruling, the court held that states should have discretion, what the court called play in the joints, to address the separation of church and state.